But I had a post where the judge said the verdict form, the object is for it to have clarity for the jury, like paging Judge Cannoni. So I
Yeah,
put that
really.
in the chat there because I didn't want to interrupt at that point. I mean, my gosh, imagine a verdict form with clarity: guilty,
Crazy
not
idea.
guilty.
Crazy. And
What
they
a
took
crazy
off.
idea.
They took off the felony murder charge, as I
Yeah,
understood it. So
that's
there's
what
just the two
that's,
now. There's the murder and the conspiracy, right?
yeah.
That's what
Well, the
I've got.
solicitation.
Oh, yeah.
It's three.
Conspiracy, murder, and solicitation.
Yeah,
But no felony murder.
yeah, and I gather the issue with regard to what I was having trouble with, and I know this was an issue in some other states, that if you're putting somebody in danger by the killing, but you're putting actually the victim in danger by your actions, which is really kind of interesting. Dan Markel is dead. So I think the jury's going to have no trouble with the charges. The question is, will they find Donna Adelson guilty or not guilty? And somebody's already asking, when do you think they'll have the verdict? Michael, we're ready for a Friday verdict.
Well, that with the breakdown of the 2 hours and 2 hours that we've been told about, that means, assuming they start at 9, right?
Yeah.
They'll do the 2 hours, they'll take a break, and then the question is, do they?
Well, they'll do the
they'll do an hour and a half. Let's say an
hour and a half. Right.
Hour and a half, and then all of
hours.
the defense, and then lunch, and then the rebuttal after lunch.
Yeah, 4 or 5.
Wait! I forgot. They have to read the instructions.
And they have to read the instructions.
It sounds like he does that first.
Yeah. So I mean, this could be.
So maybe just the first part of the prosecution closing before lunch.
He can't break up, although he may do the defense. He may do the charge. So that's 4. Half an hour to read the close. 4.5. He's starting at 8:30. 4.5. He may just go to 1.
Yeah, the jury's not starting till 9.
9. Okay, so he's got to break it up. He's got to break an early lunch up then, I guess, and then do. It's a tough.
He's got to have. It's got to be 30 minutes to read the instructions, roughly.
Yeah,
maybe longer, but 30 minutes.
30 minutes.
So then let's say then the prosecution goes an hour and a half. Okay, so now we're at 11:30.
Right,
9 to 11:30.
Lunchtime.
Take an early lunch. Come back for defense.
12:30 lunch.
From let's say 1, just to make it 1 to 3, and then they're finished from 3:30 to 4, and then they get the case and
he
probably
lets them deliberate for a little bit.
Yeah, right? Just who's the foreperson. Maybe a straw poll, and then come back Friday morning. Right. So clearly, by end of day Friday, I don't think there's any doubt that's happening.
Right.
But who knows? Could be a holdout, and then then
you'll know. If you have a holdout, you're going to know pretty early on. Because if you have a holdout, you're not going to have a Friday verdict.
Yeah.
Or somebody maybe hold out to come back to say, let's come back Monday. But if I'll tell you what, though, there was a lot of drama all of a sudden today for a case, and just for everyone knows, we will be on the air at 8:30. Michael will be here. I will be out at something, and then I will be back by 10. And at some point, I do have to take a call from overseas, whether it's while I'm out at this other matter or whether I'm on the air, just so everybody knows, even if you're not, because I know you have some.
I've got a thing at 10-ish. And then I'll be back at noon-ish, somewhere in there.
So when you come back, then I'll kind of go off, and hopefully, but I know since the person I'm speaking with is overseas, that's 5 hours, 5 hours, so that the likelihood is in the morning, and then just like now, like 3 o'clock or something like that. So, yeah.
And then we'll figure out the plan for the afternoon, because if they do get done, and we're in Justice Watch, as I call it,
right,
by 3-ish, we'll probably bail out and then regroup at 6. Do you think? Is that the plan? Or we haven't really talked about it?
Yeah, we really haven't talked about it, because I guess depends on what's happening and all.
Yeah, I mean, obviously, if they're deliberating at 3 and they have a verdict at 5, then we'll just carry out through the end of the day. Yeah. But yeah, we're going to be nimble. That's why if you subscribe,
maybe we'll just finish at the end of the day again, like we've been doing, rather than the 6 o'clock show, and then go into Friday, because Friday you're going to have a verdict. Let's face it.
I think that's certain. Yep.
I think so. I think so now. But we had a lot of drama today, and I assume what she wanted. I mean, what normally would happen. her attorneys would talk to Harvey's attorneys because she wants to know what her husband's input. Harvey, but they can't. She's not going to talk to him because of jail. Harvey's attorneys would then talk to her attorneys, and I think that she just didn't think that she'd have to make a decision today. But I do think the judge, when he mentioned contempt, I think he's built in some issues that we didn't need to have.
Well, yeah, I think that's a huge issue, that if there is a conviction, it's going to be front and center in any appeal. And it's a good one. If I'm on the defense, it's a good one. In fact, if I'm the prosecution, if I'm the firm of Kappelman and Dugan, I'm kind of concerned about it myself, because I don't want it overturned. I don't want a solid conviction overturned by something like that. Yeah. But they're in an odd position because it's really not their job to advocate for the defense on this issue. You know, they have to rely on the attorneys.
I mean, they could have made a record with a judge at sidebar and say, look, we can't.
Like, we don't object to having an extra time.
You know, they could make a record, but even your attorney, the judge, we have to be able to discuss with our attorney, and she will make the decision. We can't do it. We can't have that discussion. She's not getting us. We need an evaluation. We need more time, Your Honor.
Yeah, and if he wants to hold her or the attorneys in contempt, that just increases the strength of their appellate argument.
Right. And just say, you're making ineffective assistance to counsel argument because we can't be discussed with her. When you're discussing with a client about the right, you normally have a scrivener attorney there who takes down everything that's said back and forth. I mean, whether you like Donna Adelson or don't like Donna Adelson, or think she's manipulative or playing the system, which she may be, she may not, but maybe she really couldn't make a determination. She felt needed more time because the other witnesses hadn't testified.
Yeah, it didn't look like she was dragging her heels. It looked like, from her face and her twitchiness, like she was totally torn and had no idea.
Right, didn't know what to do. And so again, except those attorneys.
I would kind of blame the attorneys for that as well. That they, obviously you only have so much client control, but they should have been conditioning her all along the way. Keep this in mind, with every bit of testimony that you hear, with every bit of evidence that comes in, do you still want to testify? It's got to be a constant discussion in your head as you're watching this case unfold in front of you. And I don't know that they prepared her enough for that.
Yeah, and you have to build up that trust with your client, so your client trusts you if you're making recommendations. Sure. It sounds like Jackie Fulford had the most trust with her, because I call him Attorney Z, said at one point that she was the one discussing with her, and they really were in great discussion. You could see it in the courtroom.
Sure.
With everyone staring at them, But anyhow, her drama did get us, with all of your help, our great viewers, to 26,000 subscribers.
Yes.
We really appreciate that. Do you think that they're going to go a whole full 2 hours of defense? I don't think so. I mean,
the defense, not from what I've seen. Well, they have like a 20-minute opening. About half the Ms. Dugan went almost a full hour, almost exactly. No, I don't think. I just think, you might as well just say, Judge, can we have an equal amount of time? That way you're covered. But yeah, I'd be surprised if they go much over an hour.
Yeah, I'd be surprised too, because there's
but who's going to do it?
I think Fulford's going to do it. She opened. I think she's got to close.
Okay. Because it was such a weird division of labor throughout the whole trial.
And the other thing the judge said, even this is what he said. I said no tag teaming, but when they were both trying to talk regarding the Fifth Amendment privilege and a right to testify, he said, no, I have no tag teaming, one person. And that kind of that's not like handling one witness. It's like you're co-counsel to this client.
Yeah, and so the judge finally allowed Zellman to defer to Fulford on that, because she had the most contact with Donna Adelson during the course of the trial on the issue of testifying.
Yeah, and then after you presented a thing about how suicidal she is, you don't say we're having trouble, Your Honor, because she doesn't understand the implications of what we're trying to tell her. I know it's a decision, but she can't do it. We want to have an evaluation, which they could have done. Remember the other attorney who was on was actually very interesting, because she said, look, we couldn't tell the prosecution. We had to call ethics counsel, which is what you have to do. You have to call the ethics counsel. You have to get an ethics counsel to say, what can I disclose? I had that issue with one client waiting for a verdict. And the question is, what could we disclose as to what may have been an intent to commit suicide waiting for a verdict if it were a guilty verdict? and you have to get ethics counsel. It's a very tricky issue, because if the client offs themselves between, you're sitting down there and you're taking into custody because you didn't say anything, then there's liability too. But you can't then reveal what the client has told you because you have attorney-client privileges. So it's not such an easy thing. Now, people hate defense attorneys, but it's not such an easy thing. Okay, yeah. Dizzy says under the model rule, but model rules are great for modeling rules. They're not great in specific practice. Okay. Yeah. And the problem is you don't know whether you're going to have certain death or substantial bodily harm. And the problem is, again, it is your client. And the problem is if the client is not really planning to do that, but telling you, there's a lot of ethics issues. And that's why you pay thousands of dollars to have ethics counsel, because it's not so easy, Dizzy, about going to a model rule.
Yeah, and that's why model rules are littered with waffling language, like to the extent necessary. Oh, hey,
right.
Thanks
and then
for
it's
that.
Also every state is different. Every state is different too. And then there's case law that's considered. So when you have a case like that, you have to go out and you have to hire ethics counsel immediately. I mean, because you're talking about from tonight to tomorrow, and you can't tell the prosecution, and you know what can you say? You can see. It turns out maybe you can say to the sheriff's office, who is entrusted with the security of the client, please be on the watch. That's all. Maybe that's it. Please be on the watch for anything untoward. That's all. As opposed to what's going to happen. It's a very, very interesting situation. Colorado, did Donna's first attorney lie on the stand? Did the first appearance she was fighting for Donna to get out of suicide watch? Michael, I'm throwing
lie on the stand today because she said she thought she might be
suicidal,
and therefore lied about it before to get her off suicide watch. I know if she testified to the exact opposite prior and that got her off suicide watch, well, she can't be telling the truth about both, right? Either she was professing that she might kill herself, Donna Adelson, or she wasn't. So I don't know. I wasn't privy to the whatever the hearing was that involved getting her off of suicide watch. Don't know.
Yeah, it is interesting. The whole thing is interesting, and the reason why it makes it interesting is everyone thinks Donna is manipulative. I thought the interesting thing about well, first of all, with the jury charges up in the north here, when we're talking about a conspiracy, we don't talk about confederating. Okay,
confederating, yeah.
Which means have an agreement, doing something together. But the judge said when you confederate, you don't need to have words, right? You can confederate and have a conspiracy without words. There's your bicycle spoke to. In other words, she didn't need words to Charlie or to Catherine or to Sigfredo or to Luis. She didn't need words as long as her intent was to confederate to get the murder committed.
Cooperate, confederate, yeah.
Confederate. Yeah. Just I think that has to be Southern, because up there are not conspiracy statutes.
There'd be the Union up north, not the Confederation.
Yeah, have a union, right? Yeah. They had a union of the minds.
The South shall rise again.
So I had a laugh about that. So anything else that you guys want to know? Because it's been an interesting day. I think we've had a lot of talk time, a lot of discussion time, I do say that I did love the judge saying that the purpose of a verdict form is clarity. Oh dear, really?
Yeah. Choice for each. Move on, and they want to make sure each charge is on a separate page.
Yeah. And so everything that was happening. So obviously there was also a lot happening behind the scenes and sidebars and all that we don't know about. And there may even been conferences that were taken by a stenographer with defense, because the issues when they come into court at 8:30 in the morning, the judge was expecting issues, and as discussed, a couple of times it says as discussed, but it was never discussed in open court, which means it had been discussed, privately or under seal. With Judge Everett. And
remember how this morning started. It was about the whole, the female deputy who was going to talk to the defense and then wasn't available by subpoena, and then the sheriff said she was. Obviously, the defense just decided we're not getting involved with her for whatever purpose she was originally going to be testifying.
Yeah. Yeah. Just, well, I have to say, Donna Adelson did get our attention at the end.
Yeah. Yeah. I was a little surprised. I thought if she was waffling that she'd come down on the side of testifying. But I think the struggle with her was following my attorney's advice versus my ego and urge to, convince people of the truth, my truth.
And the cross-examination. I think she saw, I think when Ms. Kappelman, when Georgia Kappelman cross-examined the expert, and we saw that, and I think that was like, you see what happened there? You see what happened there? Okay. The only chance you have is that right now, as you sit here, you're presumed innocent, not guilty, and they have no evidence that you ever said anything to anybody that you wanted Dan Markell killed. But you could slip out. But Charlie,
and she had no better example than her own son. I mean, she saw that unfold, and that was ugly.
Yeah. Oh, that was ugly. Yeah, and they decided not to call Charlie also. See, they had to take things in writing also. That decision made not to be called Charlie. They probably had, a scrivener in her jail cell privately, not that she had made an election not to call Charlie. And that's a witness that they wouldn't have testified now, because we don't know. There was another witness, right? Do you want to call another witness? Was Charlie sitting back there? Was he over at the jail? And all they said, no, we're not going to call that other witness. What other witness could it be besides Charlie?
I can't imagine.
Yeah. So.
Yeah, we know he's been cooling his heels since the trial began.
Yeah. So we thank everybody for joining us. We thank Scott was in the chat, Janet, Ms. Demeanor.
Yep, and a lot of the usual suspects. Yeah. A lot of the usual suspects, which we appreciate.
And we appreciate it. And the chat will be here for you tomorrow. And thank you for hitting that subscribe, like, share button. For those of you who haven't, please do so now. We're on the march from 26 to 30,000. We want to get there by December.
We're going to enjoy the 26,000 okay, now let's move on.
Thank you all.
All right. So we'll see you first thing in the morning, and we'll have a little kind of a back and forth with Linda and I, and then we'll probably regroup after noon sometime, right?
Now, on the way out, do you want to play Oasis Cat Bump Song? It's about 3 minutes to bump.
Do we have that handy? Do we have
yes,
that handy?
We do.
Somewhere?
We have it right handy right now.
I say, why not?
I say right now, then we go.
Okay.
What does bump mean?
A bump is a law enforcement operation during which an undercover agent or an undercover police officer would conduct a face-to-face meeting or encounter with a subject or a person of interest in an investigation. And what we look for, the results we look to get would be one or a combination of either I would try to extract, or the undercover would try to extract information, or they would try to pass on information, or possibly set up a future meeting with the individual, or tickle a wire or a telephonic intercept, or tickle a wire.
In this case, was it an attempt to tickle a wire?
Yes, it was.
Okay, so we had a wiretap going at the time that you did the bump.
Yes.
Okay.
Whoa, whoa. The bump to bump tickling the wire, static whispers climbing higher underneath the quiet hum, secrets crackle one by one. Donna gets the note in her hand. The feds know she will understand. Cold
Dr. Markel's family, the Office of the State Attorney, and the law enforcement team behind this ongoing investigation will not rest until everyone that's involved is brought to justice.